Welcome to the 9 a.m. session. We're very fortunate. All right. So we're very fortunate this morning to have a panel that is incredibly coherent, both in the sense that all four papers relate to one another, and in the sense that it's like the next generation. It's like contracts, the next generation. It's four fairly junior scholars. And the way we're going to run it is I'm just going to introduce everybody now and give them 15 minutes each, and then we'll do questions for everyone at the end. So start with Kenneth Ching. Is in his third year teaching at Regent University, where he teaches contracts in UCC 1. He has already been chosen as the 1L Professor of the Year and the Law Faculty Scholar of the Year. So I would retire if I were him. Prior to teaching, Kenneth practiced commercial law, commercial litigation, trust and estates litigation, and employment law, and he also litigated constitutional issues. His forthcoming scholarship, I think it's forthcoming, you can correct me, includes Roberts on Obamacare, Liar, Lunatic, or Legitimate in the Journal of Law and Policy, and Would Jesus Kill Hitler? Bonhoeffer, Church and State in the Georgetown Journal of Law and Public Policy. They're still forthcoming?
Those are published now.
Those are published now, okay. And today Kenneth is going to tell us why Cardozo was wrong about just about everything in Jacobs and Young v. Kent, and I will just silently protest by holding this in front of my face during his presentation. Next we'll have Andrew Verstein, who is Assistant Professor of Law at the Wake Forest University School of Law. Before joining the Wake Forest faculty, Andrew taught at the Yale Andrew taught at the Yale Law School, where he was the John R. Rabin, Sullivan and Cromwell Executive Director of the Center for the Study of Corporate Law. He's also taught at Fudan University and East China University of Political Science and Law in Shanghai. He has recently published in the Virginia Journal of International Law on transnational private regulation of the derivatives markets, on the CFTC and manipulation law in the Pennsylvania Journal of Business Law, and on the law, promise, and failure of financial indices in the Yale Journal on Regulation. Today, Andrew will present his thoughts on Tempore Contracting. Wendy Epstein, they've got their backs to you, but it's Wendy here, is in her third year of full-time teaching, having VAP'd at Chicago Kent from 2011 to 2013, and she's now in her first year teaching full-time at DePaul. In addition to her contracts, teaching, and scholarship, Wendy also works in the area of healthcare law, but there's really nothing interesting happening there, so she's writing about contracts. Prior to jumping into the academy, Wendy was a commercial litigation partner with Kirkland & Ellis. She has recently published Contract Theory and the Failures of Public-Private Contracting in the Cardozo Law Review, a paper that you presented at this conference in 2012, I think. Right. And today, Wendy will present her work, Public-Private Contracting and the Reciprocity Norm. Then finally, we'll have Eric Zacks, who's an assistant professor of law at Wayne State University. His recent scholarship is focused on the relevance of behavioral sciences to contract formation, breach, and enforcement. Prior to joining Wayne State, Eric was a partner in the Corporate and Securities Department in a Detroit law firm, and he's forthcoming in Marquette, right, is Shame, Regret, and Contract Design. He also recently published Contracting Blame in the University of Pennsylvania Journal of Business Law, and today he will present The Moral Hazard of Contract Drafting. Now, Max Helveston was also on the program today. If you're here to see Max, he got bumped because all he had was PowerPoint presentations of his pug dog. So, no, he actually presented yesterday. So with that, Kenneth.
Good morning, I'm Kenny Ching, and so today I'm going to talk about Jacob and Young's versus Kent. I want to use that as a vehicle to talk about contract theory. I'm going to be talking about positions that I characterize kind of along the spectrum of individualism, collectivism, and Thomism. And then I also just want to tell you some surprising things that I found about Jacob and Young's as I was researching this case. Hopefully might be interesting to some of you who teach this. All right, so this is the mansion that George Kent, a New York lawyer, hired Jacob and Young's to build in 1913. The contract price was $77,000, translated to today's money about $1.8 million. Pretty good, I think, for $1.8 million, if you can see it. The contract specified that reading pipe was to be installed as the plumbing. And unfortunately, Jacob and Young's did not entirely install reading pipe. The architect who was supervising the job certified that this was a failure to perform the contract, and so Kent withheld a balance of about $3,400 on the that was outstanding, which translated to today's money is about $80,000. Just note that that's about 5% of the contract price that Kent withheld for non-performance. So Jacob and Young sues. At trial, Jacob and Young's loses decisively. The trial court directs a verdict for Kent. Apparently, although not explicitly on the theory that the installation of reading pipe was a condition precedent. So there's a couple of appeals, and Jacob and Young's goes up in front of the New York Court of Appeals, and there they prevail. They have a pretty dramatic reversal of fortune because Judge Cardozo, writing for the majority, directs a verdict for Jacob and Young's. And so the main question, although there's a couple of other important questions, was whether this reading pipe term was a condition, precedent, or a promise. Cardozo says it's a promise, not a condition, so Jacob and Young's did not forfeit their rights to be paid the outstanding balance, and Kent basically loses at the appellate level. So a couple of surprising facts about this case, but before I get into those, I just want to frame the way we're going to approach this with a quote from Judge Cardozo. One must permit oneself a certain margin of misstatement. And I think this case is full of misstatements. I'm only going to touch on a few of them. This first issue about whether the reading pipe term was a condition, you'll remember some of this language from the case, this really, really famous language from Judge Cardozo where he talks about, oh, this is a question of sort of intent and justice and what we can reasonably think that the parties were trying to accomplish. But it's all premised on this notion that the contract itself was silent, that it didn't say much about whether the reading pipe term was a condition. So you get this language. The law will be slow to impute the purpose that the term was a condition in the silence of the parties. And it's after this that you get all of Judge Cardozo's pretty literary language about figuring out this question. The thing that surprised me was I just went back into the record and I read the contract. And the contract is replete with the theme of strict performance or else forfeiture. It goes on and on and on, way too much language to produce. But this idea that the contract was silent on that point, I think is a misrepresentation. Either Cardozo didn't read the contract or he didn't want to talk about it. And his biographer Kaufman said that he did this a lot. He didn't really like the details. He kind of liked the big picture and the story. And one way or another, this contract did not get represented very clearly in the appellate opinion. So this is just a summary of many, many terms. The contract clearly said that the contractor, Jacob and Young's, had to remove any materials condemned by the architect. The architect did condemn the materials. The contract says that if you don't do what the architect says, then you forfeit your right to payment. And I think this is important because I argue that this is essentially the definition of a condition. Something has to occur or the other party's duties to perform are discharged. And so they've pretty much described the situation where a condition fails to occur. And so Kent doesn't have to pay. He doesn't have the duty to pay Jacob and Young's anymore. Contract's clear that the decision of the architect is to be final and conclusive. And this isn't just for Jacob and Young's. This is for Kent as well. The architect, I think, was supposed to be the arbiter between these two parties, because the contract makes it clear that the architect gets to say what has happened, what hasn't happened, and the contract, the architect here said that Jacob & Young's hadn't performed. He condemned their work, he certified that failure, so Kent didn't pay, pretty much pursuant clearly to the terms of the contract. To put a fine point on it, the contract also says that the owner, Kent, has the option to keep the defective work, and in that case, receive the difference in value. You may remember, this is basically what Judge Cardozo ultimately gives Kent, but the contract sets that up as an option, which to me suggests the default was strict performance. All right, I've got to move quickly through these things. So that was a factual issue that was surprising to me. The contract was quite different than I think Cardozo's opinion makes it seem. Some legal issues. I think Cardozo pretty much hurdles over every legal issue in this case, but he trips over each hurdle along the way if you look at the law. So just one issue. Cardozo very briefly suggests that you can substantially perform conditions. I'm not going to go in depth on this, I do in my paper, but you just can't substantially perform conditions. It wasn't the law then, it isn't the law now. Cardozo kind of finesses that point. But even if you disagree and you say, no, I think you can substantially perform conditions, there's just no way to get to substantial performance here. Substantial performance has a test. 3 elements: good faith, substantial compliance, and proof of fixing the defects. So here, the evidence of good faith was that the subcontractor who was responsible for installing the reading pipe said that it was an accident. He didn't mean not to. I mean, in other words, he didn't do it intentionally. The first time the pipe showed up at the house, he checked. He knew he was supposed to install reading pipe. He checked the pipe to make sure it was reading pipe. He had gone to Home Depot or whatever and ordered reading pipe. But on subsequent deliveries of pipe and installation, he testified, I just stopped ordering reading pipe and I just stopped checking whether it was reading pipe. He doesn't quite explain why I'm calling that an accident. But that's the evidence of good faith here, was that the subcontractor, basically the culpable party, said it was an accident. The next element is substantial compliance. You have to show that you did do most of the work. Here, there's just literally no evidence. The reason is the trial court excluded the evidence because they were satisfied that there was a condition precedent that hadn't occurred. But as a matter of just fact, when the case shows up on Judge Cardozo's desk, there's no evidence on this point. The way Cardozo deals with it is he says, I think the evidence would have shown substantial compliance, but this may be a kind of technical procedural point, but that's not usually the way we decide questions like this, where the judge says, oh, I think there was substantial compliance. Usually you want some evidence. Same with proof of expense of fixing the defects. The contractor who breaches here is supposed to show how much it would have cost them to strictly comply. Just literally no evidence. All right, so even if you think you can substantially perform conditions, I don't think we got there here. All right, now I want to move into kind of the theoretical piece of this paper. I really want to use this case as a vehicle to talk about contract theory. And I want to go to this question that's central in contract theory about why do promises create moral obligations? Most people think that they do. The question is why? And I want to look at this individualistic perspective, a collectivistic perspective, and then explain why I don't think those do the trick and turn to this Thomist perspective. I like this case as a vehicle for these perspectives because one way to read Cardozo is he's doing the kind of paternalistic collectivist thing. McLaughlin, the dissenter, stands in for the individualistic perspective. You might remember that McLaughlin writes in his dissent that the defendant contracted for pipe made by reading. What his reason was for requiring it is of no importance. He wanted it, and he was entitled to it. In other words, hey, that's what you agreed to, that's what you get. We don't inquire into whether we think that was a good idea or not. So I take a look at Charles Freed's really classic book, Contract as Promise, where he lays out one of the cases for an individualistic approach to contracts. It's based on human autonomy, right? And other people like Randy Barnett are still writing in this vein, this individualistic approach to explaining contracts. So Freed says it's about human autonomy. When an autonomous human being makes a promise, he binds himself to that promise. Secondarily, when an autonomous human being makes a promise to another human being, he evokes the trust of that other human being, and so it would be immoral to abuse that other person's trust. Problems with this. It's not clear to me or anybody else, as far as I can tell, how an autonomous human being binds themselves by making a promise. Even if they do bind themselves, why can't they unbind themselves? It's just a kind of contestable anthropology. Second, and probably most importantly, is the subjective conception of what is good. Charles Fried says, it's our own conception of good that we pursue, and a court really doesn't have any theoretical resources under this approach to inquire into whether a contract's fair or not. Okay, it also doesn't describe most of contract law, which Fried has conceded. We then get P.S. Atiyah. P.S. Atiyah represents for me this collectivist point of view. He says, yeah, the reason you're wrong, Charles Fried, is because contract law is deeply paternalistic. What makes a promise moral or not is whether society says so. And we represent in contract law society's moral values. The problem with this perspective for me is that that isn't what I'm interested in, and I don't think it's what most people are interested in when they ask about a moral obligation. It may be true that society says so, but that doesn't usually answer the question of why you ought to do something. That just answers the question of why prudentially maybe you have to do something. And in fact, Atiyah says, the mystique of morality, if any, is simply a way of fooling people and thus exerting greater control over their minds and their behavior. To the contract point, this ignores the voluntary nature of contracts. Everybody, as far as I can tell, still cares about whether people volunteer for contracts. But if what we're ultimately concerned about is social norms, there's no theoretical reason to respect the voluntary nature of contracts. Why not just force people into contracts or transactions that we think are beneficial? So if you're one of the people that likes Cardozo's opinion and Jacob and Young's, I would suggest that the way you like it is on a Thomist reading of that case, which I think brings together the good pieces of both an individualistic perspective and a collectivist perspective. The Thomist, and by Thomist here, I'm personally talking about works by James Gordley, John Finnis, Thomas Aquinas, and then some other people. It's a long tradition, so there's probably a lot of people that you could call Thomists if you wanted to. For the Thomist, morality is defined by reason. They say that the law is directed toward the common good, and if you want the common good, which is the social conditions necessary for human flourishing, reason tells you that promises must be kept. It's the only way to get to certain aspects of the promise of the common good. So let me just give you an example. Let's say that you and I all agree that widespread gainful employment is a social condition necessary for human flourishing. If you want widespread gainful employment, reason tells you that people have to keep their promises in general. It's not because society says so, it's not because individuals say so, but because reason sort of points the way to get from point A to point B, the common good. So I think McLaughlin, the dissenter in Jacob and Young's, gives you an individualist perspective on the case. I think Cardozo is actually doing the paternalist perspective, at least in his heart. I think on the surface, his opinion looks very Thomist, and I think if you like his opinion, you like it in the way that a Thomist would like it. Unfortunately, I don't think his opinion is the right opinion for the actual facts in this case because of some of the omissions that I've brought up today. But looking at this case from a Thomist point of view, Thomists say that a promise has to be reasonable. It has to be directed toward the common good. And so one of the ways of figuring out whether a promise is unreasonable is by identifying an inequality in the contract price. They're going to say that you have to pay, a market price for the contract that you entered into. So you might ask, did Kent pay market price for the reading pipe term, this kind of strict performance of some aspects of this contract? And so you need more evidence, frankly, to answer this question. But I guess I would point out one thing. One, in this case, there was no allegation that the contract was unconscionable. Jacob and Young's doesn't argue that, hey, this wasn't fair to us. They argue, when they're litigating it, that they substantially performed. So that suggests to me that the market price was not really an issue. Jacob and Young's agreed to pay them $1.8 million in today's money for the job that they were going to do, including some strict performance of certain terms. The injury, well, Jacob and Young's did get 95% of this contract price. To me, most interestingly, is Jacob and Young's ability to protect themselves. One, they're a substantial contracting firm. It's hard to believe that they got steamrolled in the contract negotiations. Two, it was really easy for them to do what they were supposed to do here, at least on the reading pipe term. The subcontractor said, at first, I knew I was supposed to install reading pipe. I checked to make sure it was reading pipe. All I had to do was go and order it. I just stopped doing that. Not very expensive for them to strictly perform in this case. All right, so I'm going to wrap up here and just suggest to you that these individualistic and collectivistic perspectives don't answer all of the questions in a theoretically satisfying way when we look at a case like this. A Thomist perspective brings them together. It respects the voluntary nature of contracts, but also gives theoretical resources for inquiring into the substantive fairness of a contract. Thanks.
Hi, everyone. I'm Andrew Verstein. I'm happy to present Tempore Contracting to you. So this is a paper that uses Prezi, which is software I've never used before. I have two things that I'd like to do with you today. One is this theoretical thing that is what got me interested in this. I want to describe, criticize, and expand upon a way of looking at contracts that is popular in certain circles these days. And looking at how parties do draft contracts, how they should draft contracts, how courts do interpret them, how they should interpret them. I'll tell you more about what theory that is in a moment. There's also a part where I'm going to be applying this to a certain type of dispute resolution technology in the construction industry. This may be independently interesting to you. It was for me. I found this cache of cases from these dispute resolution boards. Nobody else had seriously written about them before, and nobody else had found a large number of cases before. So you should check my footnotes if you want to learn more about those and write a different paper based on them. The approach that I want to criticize is one that I call the ex ante ex post approach. The proponents of it or the users of it don't use that language. There are many people, they use different language to describe what they're up to, but I think they've got a common thread running through them that they're using this approach. And this approach that I want to describe, expand, and criticize or whatever is like this. Two people want to get together and they want to do a project, and the project is going to create responsibilities for them. And they get to decide, there's going to be a process that decides what their responsibilities to one another are. Okay, so let's say they're going to build this big mansion, and it's Kent and Jacob and Young's are the two parties. Well, for each responsibility they have to one another, they have, the story goes, two ways of determining what that responsibility is going to be. One way is that they could decide it themselves. They could say, let's make our quality term be reading, not co-host pipe. Let's write that down and hope that Cardozo reads it. And what should the price be? 76, no, 78, 77. And then they write that down too. And now the price term and the quality term has come from the parties, okay? And that is part of this ex ante approach. Okay, so first option is an ex ante approach. The parties have created the responsibility. How did they do it? They thought about the future. They decided what they would want. They negotiated and bickered with each other about that, and then they wrote it down. When did they do that? They did that at contract formation, of course. That's how they were able to write it down. And why? Well, writing it down gives them very clear incentives for the future. It makes everyone certain about what their responsibilities are, and it's going to reduce litigation costs, all the good reasons that when you are in practice or when you go to practice, you'll tell your contracting clients to write things down. But the parties have another choice other than the ex ante approach to creating contractual responsibilities, so the story goes, and that is the ex post approach. And this approach says, don't write down reading pipe, write down good pipe. And write down reasonable price, or don't write a price at all. And if you do this, you'll still have a contract as long as the other things are lined up. You'll just have an ex post contract for those terms. And that's a contract where the court or arbitrator is going to be the one who decides what you owe each other. Is this reading pipe or non-reading pipe compliant with the good pipe term? Was that amount of money tendered good enough, a reasonable amount of money tendered? The court will decide. And what will they do? They're going to plug in missing terms for you. They're going to specify the extent of vague terms for you. When? After. I'm going to use that term broadly. After the dispute, after the relationship, after the conflict, after the performance, after something. It's going to come later. Okay, certainly after the drafting. And why might you do this? Well, courts have hindsight. They can know later what the pipe market looks like and whether, given the improvements in co-host pipe since the drafting of the contract, it now would be good enough. The court knows things that you don't know because it's operating later. It's also really difficult and expensive to anticipate and draft everything. Many things, okay, fine, but everything, very difficult and expensive to draft in rational ways. So you might be motivated to go to this ex post approach, okay? And so for each term, you get this choice, and you could have some terms that are ex ante derived and some that are ex post derived. And this account, this ex ante ex post account, says how do people operate? How should people operate? Well, what they should do is they should draft to minimize the sum of those ex ante and ex post costs, or maybe maximize the benefits of ex ante and ex post contracting. You should leave some things vague and some things precise for that reason. And that's going to tell you to do things. It's going to tell you, look, if there's something is costly to litigate, plan it in advance, because that ex post way of getting the term will be pricey, because litigation is pricey. Or if the clarity of the term is going to lead you to be, to put the right pipe in and not knock the house down later, that one might be one where you want to have clear obligations. But there are also things where it's costly to draft it. Maybe you'd have to do a lot of research, or the parties would have a lot of trouble negotiating. Maybe there's 100 parties to the contract, and it would be really hard to get them all to sit down. So maybe you leave something vague there. Or if something's extremely unlikely, asteroid collisions with the Earth, maybe you don't make plans for that. It's just not worth deciding what you would want to do in that circumstance. Leave it to the court. And what should courts do? They should, and do, interpret in such a way as to help you with this, as to minimize your contracting costs all told. And that means things like, well, the people I listed on the list as the scholars representing this view, they're mostly formalists and they're mostly textualists. And so for them, a formalist, textualist feeling arises. And so courts should not get involved if the parties have said reading pipe, whatever that means, or 77,000, whatever that means. And so, cases like Alcoa, where the court looks at clearly written contract terms and lets the parties have a new price, would be the kind of thing that these scholars would be critical of. Because that wouldn't help the parties to make their choice about how to allocate. When the parties have allocated vague terms, you should give them what terms they would probably want, or what most parties would probably want, because that way they can get what they probably would want by leaving it vague. But sometimes you should give them what they don't want. Because if you sometimes give them what they don't want, that's gonna create good incentives in various ways too. If you raise the cost of ex post contracting on this one term, because people know they'll get things they don't want, well, that'll force them to do ex ante contracting, which might be what we want. Maybe we're afraid in Hadley v. Baxendale that the person who's paying for shipment is not disclosing the quality of the items they're shipping. And so we craft a penalty default term that will force them to explain to the FedEx equivalent what's in the box, so that the optimal care can be provided. So this is the kind of prescription that comes out of it, and parties become aware of that, and that takes us back to the front of the circle where the parties know about what courts will do, and that helps them to draft appropriately. So this is the cycle of ex ante, ex post interpretation drafting. And a final summary slide of where we stand. As for where terms come from, they can come before and by virtue of the party's own action. That's an ex ante approach. Or the parties can punt to the future and have the court determine their duties later. But of course, look, there's a middle spot that just is begging for another piece of the puzzle. It's just begging for it. What is that piece? Well, is there a time other than before and after? There's during, right? There's some sort of real time in the moment, some sort of extempore kind of spot. And then who else besides the parties and the court is there in the world? Well, there's everyone else, okay? And you could imagine a contract that had its duties determined after before and before after and by some third-party agent. And so I want to call that extempore contracting, or extempore determination of terms. It's a pairing of a time and a decider, okay? I want to claim that this is a theoretically important spot in the chart. You could shoehorn everything in that Lego piece up and down. You could do it, but you would be missing a lot. It is worthwhile to notice this because lots of things fit in this box. And lots of things that fit in this box operate other than the things outside that box. They have a logic to them that can be understood and learned from. So I want to tell you, just as a very simple example on the Jacob and Young's thing, how might you draft an ex tempore term? One way you could do it is say, well, we're going to have good pipe. Or we're going to have this clause that says, and Jeremy's going to come every week and tell us what we owe each other with respect to this pipe and other things. He's going to fill it out.
Right is my ruling.
The judge is right. Who's right?
Cardozo's right. That's always my ruling.
Okay. Well, now we're going to punt to another third party, the judge. But so the idea is that this is a contract term that is seemingly vague, but it's going to provide certainty at the time the pipe goes in. You're not going to have any doubt at the time of pipe, so you get clarity and you get to punt as well. To go through the same questions as before, here it's some non-judge, non-party that's determining the content of contractual obligation, and they're doing it on an ongoing basis, just before, just after, just during an ambiguity, a vagueness, a conflict arises. And they're going to operate on superficially vague and superficially precise terms. I won't get into that very much here, but there are terms that appear to be precise but aren't because of this. And why might you do this? Well, the same reason that the dominant view says you're doing this. You want to reduce the total cost of contracting or increase the total benefit of contracting. But it's a 3-variable equation, not 2. Okay? And the kinds of cases where this might be useful are cases where you do want clear duties, but you don't want costly litigation. It would be costly to litigate X, and it would be helpful to know X at the time you perform, but you do want hindsight. You want to know what the price of reading is at the time that this happens, and you do want to save those initial drafting costs, because who knows if this will ever be a problem. Why figure out the asteroid problem in advance? Okay, so this is the Ertan Dam, the Ertan hydroelectric dam in China. It is a big Chinese dam. It is, of the type of dam that it is, it's the 3rd largest in the world. It was built from 1991 to 1998, long time. It was a $5 billion dam. Lots of people involved in the construction. Chinese design firm and Chinese engineering firm, Italian construction firm, German drilling firm, 3 other firms, plus the subcontractors, plus the suppliers, plus the workers. 40 major disputes emerged during that period. Not surprising for those of you who know construction. Construction is the most disputatious area that I know of, other than boxing or something. And construction is a mess, okay? And international construction, this is not the most easy. This is not the easiest time to do business in China, right? I mean, there's all sorts of things that make this naturally a candidate for disputes. I'm bringing this up because there is an example of ex tempore contracting that's going to be pulsing in this case, and that's to demonstrate to you that it exists and matters. Well, here's a fact: is that 6 months after the completion of the project, there were no disputes outstanding, and there was no litigation that had been concluded as litigation. So every claim had been resolved, negotiated, settled within 6 months. It's just a very uncommon story in a contract case. Okay, what features do people often think led to this this really nice result for the parties involved? Well, some people like to attribute it to the existence of construction dispute boards, dispute resolution boards. These boards are neutral expert panels. They are 3 engineers maybe, or general contractors or something, people with experience at the nitty-gritty. They show up on site whenever the parties ask, or with some frequency, maybe every 3 months or every 3 weeks. They show up and they walk around, they kick the tires, they ask, anybody have any disputes that you're brewing? Is there a contract term you'd really like someone to clarify for you right now? I know you're not yet in litigation, so heads are cool. In fact, I'm showing up now in the first month of the project. No cement has been poured. I mean, we're establishing a relationship where I'm going to be becoming familiar with your needs and the contract's logic long before we're in a disputatious place. And when I give you an answer, that determination is going to have some features that can be varied by contract, but typically they're not enforceable determinations. You couldn't go and get a sheriff to levy a judgment, but they are considered to be contractually binding on the parties, and my report will be, we've stipulated that subsequent adjudicators could probably see this report and think accordingly. people think that these dispute boards, which are a relatively new contracting technology, they didn't exist on planet Earth until the 70s, and they've become very common starting in the mid to late 90s, and are now extremely common in certain kinds of government construction. So my cache of cases that I'm reading to try to come up with this are all Florida cases, Florida dispute board cases that they put online. These things seem to be pretty effective. These are statistics that need footnotes because they're too good to be true, and you should read my footnotes. But 98% of disputes brought before the dispute board are resolved without trouble, without subsequent litigation or mediation or anything. It's just done. And each of these disputes is resolved at something like 10% or 50% of the cost of even arbitration, which is cheaper than litigation. So you're getting rid of everything and cheap. And people seem to praise it and actually enjoy going through this process much more than they enjoy being held down in depositions and stuff. So it's a miracle, right? I want to claim that this, and with my 7 seconds remaining, I want to claim that this isn't, you shouldn't think of this as a really neat form of arbitration or a really neat form of mediation. You should think of this as extempore contracting. Contracting in the construction industry is very costly. It's very difficult to write a long contract that covers all the subcontractors, all the materials, and all the things that come up once you dig into the ground. But litigation is very expensive in construction too. And so ex post contracting is very expensive. And yet people, the status quo was that people did a lot of both, like a lot of ex ante costs and a lot of ex post costs. But this extempore option is you could punt the term to this dispute board and say, I don't know what the price should be for that. I don't know what your responsibility should be. Do you have an implied duty to find employees for me if I can't find any? Is reading pipe going to be the only part? We don't want to think about that now. We also don't want to think about it later. It's going to be so horrible to think about it later. Let's let the dispute board think about it for us on an ongoing basis as it becomes relevant. This is going to provide all sorts of benefits that the parties like. It's not just adjudication for reasons I'm happy to take Q&A on, though that's definitely pushback I get a lot of. There are payoffs to seeing the world this way. One thing is that it has a theoretical payoff to the debate that I'm weighing in on. So just as one example, those penalty default clauses that I alluded to, the idea that you might give parties what they don't want at litigation so that they'll negotiate ex ante better. People who know a lot will be candid with people who don't know a lot. That is a utopian vision on this view because parties could move from ex post contracting, not to ex ante contracting like you hoped, but they could move to ex tempore contracting. They could say, all right, I'm not going to put in this term hoping to predaciously take advantage of the default term. The court won't give me the one I'm looking for. But I am going to put in this ex tempore clause that I'm more familiar than you are with the way that this agent resolves things. This is an agent that I trust or like and know. And so there's whatever predation you're worried about that you were drafting penalty default clauses for, you should be worried that they're still going to be in there. They're just going to be coded a different way. And that's just one theoretical payoff as how we instruct judges to, okay? And also another payoff is you find secret agents everywhere. So these ex tempore relies on agents, right? These agents who are determining, and with dispute boards it's clear, they show up, they have glasses, they go off a clipboard, but there are secret agents out there, agents that are doing this and you don't notice that they're agents doing this. I think that the Trade Association for Financial Derivatives is in this line of work. I think that anybody who has a LIBOR-linked mortgage or has a financial derivative based on an index, I think anybody doing that is relying on a secret ex tempore agent for reasons that another paper elaborates. I think that when people take the default terms of a corporate code, they are in some sense delegating the responsibilities of the contract between shareholders and bondholders to the Delaware legislature. I think there's a lot of delegation of contractual duties that people engage in that is usefully illuminated and spotted with this approach. Finally, seeing this might invite you to use this in a contract that you would never have thought to use this in. I think there are a lot of really problematic types of contracts like earn-out agreements in M&A or complex contracts for innovation, really difficult to contract, hard to litigate, hard to draft in advance. Try a third way now that you know it exists. There might be a way to get a dispute board into some of these complex contracts. But we do need, of course, support our institutions of ex tempore contracting where they exist. And courts largely do that, but I have in the paper a couple places where courts act in a way where they misconstrue it and they think, hey, this is just mediation and we'll act accordingly, or this is just arbitration, we'll act accordingly. And getting it wrong, thinking that it is something other than it is, leads courts to get it wrong. So here we are. Thanks.
hesitant to take down these Lego guys because I love Lego guys. Let me do it anyway. Where did it go? Okay, so thank you very much to Jennifer Martin and to St. Thomas for having me. This has been such a fun panel so far, so I'm happy to participate with these guys. So my paper is on public-private contracting and the reciprocity norm. When I refer to public-private contracting, I'm actually talking about mostly government outsourcing of services. So I had been focusing on the state and local level outsourcing, so things like states running private prisons or outsourcing their welfare administration. But I've had such a wealth of good stuff coming out of the federal government these days that I'm now expanding my reach a little bit. I'm talking about the failed Obamacare website, and also you probably have seen in the news that there's been a lot of press about the government outsourcing their security clearance process. The firm that had given approval for Edward Snowden and Aaron Alexis, who was the Navy Yard shooter, were both approved by a private outsourced company. So I've got a lot of fodder here. In a prior paper when I was writing about public-private contracting, I identified what I consider to be a problem, which is that the two parties to the contract, so the government and the private agent, or the private entity that's actually administering the service, they tend to impose a cost on third-party beneficiaries in the form of poor service. And this is because, and this happens not in all contracts, so not in the types of contracts, and you'll see this in a little bit, where we have, we've outsourced garbage collection services or something like that, but more so in contracts where there's a thin market, so we don't have a lot of competition, and where it's very difficult to specify and to monitor. So a lot of actually what Andrew was just talking about as well, that it's just very difficult to write everything down beforehand. And so I argued that in those services, in those types of contracts, you tend to see this, what I call the negative externality that's being imposed on these third-party beneficiaries. So in this paper, I want to focus on a related, or maybe actually a subpart of the same question, which is now I want to assume that the government has the right incentives to procure good quality service, but that it can't procure good quality service because of the way that it's drafting its contracts. So I'm going to lay out my thesis and then I'll sort of go through each of the parts. So the first is that it's difficult to control agency costs in certain contracts for government services. So again, the government is outsourced to a private entity, and it's just hard for the government to know what it is that the agent's doing, to specify and to monitor appropriately. All right, so there's been a lot of ink that's been spilled on this topic, and what scholars have basically said, both in the private law and in the public law vein, is that the way to fix this problem is the same way that you would mitigate agency costs in any other scenario, which is by writing better contracts. And usually when people talk about writing better contracts in this context, they're talking about more detailed contracts that more specifically specify the tasks for the parties, that have very robust monitoring provisions, and that try to align incentives by using performance-based incentives. So in other words, if you meet these particular criteria, then we'll pay you more money. I argue that this actually doesn't work in practice, at least for the types of contracts that I'm particularly focusing on. The reason it doesn't work is that, it's hard to specify, and you don't get good monitoring, and you tend to impose costs on these third parties. And I'll get to that more in a little bit. My solution is something that may seem counterintuitive, which is that less detailed contracts may actually prompt higher levels of service than rationality predicts. So sort of like Andrew, I'm focusing on the parties' behavior during the contract. So I assume that they cannot draft perfect contracts ex ante. I do talk a little bit about the cost, although my concern is more about can they actually prompt good service that way, and I argue that they can't. And actually, I found that the vast majority of these types of cases, even if they don't go well, don't result in litigation. So these big government contracts very rarely result in litigation. So I'm focused on how can we fix this problem during the course of the contract. All right, so let me talk just a little bit more about the problem then. The whole idea behind government outsourcing or privatization is supposed to be that private entities can provide these services more efficiently and more effectively than the government. So whereas the government is essentially a monopoly, And so if you introduce competition, that the private entities will be motivated to perform the services better. They also don't have to navigate this vast bureaucracy that the government has to navigate. They have better access to private capital. They can set wage levels, and so they have more flexibility than the government in that way. In practice, though, certain types of these contracts, as I said, can be problematic. So I've highlighted here that particularly where you have a shallow market or a thin market for services, which in the types of contracts I'm focusing on is quite frequent. If you want to talk about footnotes, I have a long footnote of contracts where there was only one bidder. Where the tasks are difficult and hard to specify, so it's just hard to say what it means to run a good prison, or education is another example that comes up a lot. This is why you get teaching to the test type of things. It's hard to say what it means to provide a good education in a contract. And then narrow application there, I'm talking about these contracts tend to be more problematic where they're only affecting a very small segment of the population, particularly when they're affecting a small disenfranchised portion of the population that doesn't have a lot of political power. So in my red box, I've plotted just a couple of examples here: private prisons and welfare administration. Those tend to be the most difficult for outsourcing from the perspective that they tend to end up providing poor service, or at least they're biased to provide poor service. We could also talk about some of these federal examples. I discussed in the paper, as I said, this recent one that just came out about the government having outsourced security clearance procedures. It turns out that the problem with this contract was actually discovered in part because we had these two very bad events that happened with Edward Snowden and with Aaron Alexis, but also a Department of Defense audit caught what was going on there, which was that the private contractor was doing what was called flushing applications. So at month's end, when they needed to get paid, they were getting paid by the applications that they completed. They're basically just approving applications without having gone through the full process of checking this for the security clearance. Part of the problem there, obviously, is that, again, it's hard to say what it means, or hard to dictate in a contract what you have to do to have done a good job checking for security clearance. So perhaps you could detail a number of steps, but there's a lot of discretion involved in this. Okay, so that could be plotted on my chart as well here. Not surprisingly, many scholars have discussed this problem. As I said, both public law scholars and economists, and they largely agree that parties should write better contracts. And perhaps this is somewhat intuitive as to why this might be the case, but the idea is if you have to constrain a rational actor from shirking during a contract or from doing things that you don't want them to do, well, you should exert more control over this actor. And how do you do that? Well, you should specify exactly what it is that you want them to do so that they don't screw up. You should put in very intense monitoring provisions so that you can check to make sure that they are actually complying with what you have asked them to do in the contract. And then you should try to create other incentives for them to behave well instead of behaving poorly. And so you should provide financial incentives. Although there's little empirical data on what these contracts actually look like in practice, there's a lot of anecdotal data that you do see this type of contracting mechanism. You see government contracts getting longer and longer, trying to specify in more and more detail. And perhaps this is a little bit of trying to protect the government actors if something goes wrong during the course of the contract or afterwards. It's very helpful to say, hold up this long contract and say, I did everything I could. I specified in a lot of detail what I wanted them to do, and they just didn't listen. And so it provides some sense of insulation. So this approach is probably not surprising, particularly given political pressures. But nonetheless, and by the way, it came to mind yesterday when I was watching Kingsley Martin's presentation at lunch that he wasn't talking about government contracting necessarily, but he was painting a very vivid picture of what contracts look like these days. As he was talking about the piles and boxes and lots of pages he had to go through to discern what the common terms are in these contracts. I think that government contracts are probably some of the worst offenders in this regard in terms of trying to paper over as much as possible. So I obviously argue that this is not the way to do it, that current solutions don't work particularly well. Why? Well, they're predicated first off on a well-functioning market. The idea is that people are going to want to do a good job in these contracts and to comply with the specification, because if they don't, they'll be switching options and they'll lose the contract at renewal. And generally, this is one of the ideas behind outsourcing, is that you'll create this market. But in practice, we see that oftentimes there's not a good, well-functioning market. There's only one bidder. There just are not a whole lot of companies out there that are well-positioned to run a private prison, for example, or to administer welfare benefits for an entire state. So we see lack of a well-functioning market. The second is that we have these specification and monitoring difficulties. So this might seem a little circular in the way I'm defining these contracts are the ones that are problematic. But the truth is that if you want this method of constraining agency costs to work, it has to be the case that you can specify and you can monitor. And when it's difficult to specify and difficult to monitor, then this very detailed contracting solution doesn't work particularly well. The other problem is that you outsource in part so that the private entity can innovate. At least that's one of the arguments or one of the reasons that people support outsourcing. But if you very much specify exactly what it is that the private entity has to do, you kill the very innovation that you're trying to initiate in the first place. So I'm suggesting a different approach here. The approach that I'm suggesting is based on behavioral economic studies and positive reciprocity. And it turns out that it's the case that that there's this new literature that's set in an experimental context, and I'm going to talk about some real-world examples as well, that find that people behave in ways you wouldn't expect, in ways that rationality wouldn't dictate, when you treat them well. So probably the most famous example of just reciprocity is the ultimatum game. You're probably familiar with it, but the ultimatum game basically was a setup where two parties had to divide a pot of money. And the first party makes an offer to the second party decides whether to accept it or not. So fully rational actors in this scenario, if they were fully rational, the first party would make a very small offer, and the second party would accept it, because the second party is better off walking away with any small amount of money than they are walking away with no money at all. In practice, though, the numbers didn't work out like that. The evidence showed that if the first party proposed anything less than 20% of the total amount, the second party would reject the offer more than 50% of the time. In other words, people were reacting to the perceived fairness of the offer and not as the rational actor model would predict. So how does this relate to contracts? The most often cited study in the contract context is done by Ernst Fair. And what he did, he's done many studies, and there have been other studies that have confirmed his results. But so let me just talk about one for sake of example here, is that he demonstrated in one-shot games that because of the reciprocal inclination, that less complete contracts induced higher effort levels than more explicit contracts. So this was the setup. It was a simulation of firms and workers, and the study compared these explicit and implicit contracts. The implicit contract set a wage and did not define an effort level and did not have any financial-based compensation or incentives built into it. The explicit contract defined a wage, also set a desired effort level, and then permitted fining or penalties for not complying with that effort level. The game had 3 stages where the principals chose contracts, the agents agreed to them, and then the agents set their effort levels. And the results indicated that the agent's effort level in the implied contract, where the completion of the specific results wasn't tied to incentive compensation, was 5.2 on average out of 10, while the effort level in the explicit contract was 2.1 on average. So again, I said this is just one experiment, but similar results have been confirmed in many other experiments. Now I know I'm going to get the pushback, well, this is an experimental context, what can we really learn from this? Do people really behave like this in the real world? So this is something I've been giving a lot of thought to. And I talk a lot in the paper about the regulatory context by way of analogy, where there's been this big move away from command and control regulation towards more standards-based regulation. And the reason in large part was based on results of studies on things like greening in the car industry, and I talk in the paper about nursing home regulations, where they found in real-world practice that if you tell an actor very explicitly what you need to do, make the regulations very robust, that it turns out the results are not as good if you just say, make cars more green, make cars more environmentally friendly. So let me just end by acknowledging, as I do in the paper, a few limitations or things that I'm still working through, and I'm particularly happy to get comments on these things as well. And the first, I guess there's not a whole lot to say about this one, which is just the fact that this is largely based in experimental literature. And I think that much more work needs to be done in testing this reciprocity norm in the government context, but also just largely in a firm level context. A lot of what we see is individual to individual interaction. So I think more work needs to be done in that area. Although I do think that this regulatory example is a very good analogy. And then there's also some practical concerns that I'm still working to address here, which is how do we provide enough in the contract so that the parties know what it is that they're getting into, right? You can't have a contract that's completely vague. This is all in a spectrum of something that's very, very detailed, which is what we have now, and something that I guess would be not even a contract at all. And I'm suggesting that you've got to fall somewhere in the middle, and that that the parties need to find some way of describing what the goals are, what they're trying to accomplish, without specifying to every detail, this is the type of paperclip that you need to use on your paper. But how do I prevent a race to the bottom on price then? Isn't part of the reason that these contracts are designed this way is to prevent corruption? I think there are some answers here. I think that I'm talking specifically about contracts where we don't have a lot of competition, so really we only have two entities that are likely to be the ones that are the contracting parties in the first place. But these are some issues I'm still working through and would love to get feedback on. I guess that's it. Thank you very much for having me.
Good morning. I'm Eric Zacks from Wayne State University Law School. Thanks to Jeremy for moderating and to Jennifer for hosting us and to all of you for attending. So, as you've seen from the setup so far, in contract law we talk about economic agency a lot, but we always talk about, or we usually almost always talk about it, about the economic relationship, the agency relationship as it exists after the contract has been formed, after the promises have been made. So that one of the promisor is an agent, the promisee is a principal, and because of the differing interests, the information and control, the agent, the promisor, may be able to act opportunistically, right? And so we talk about, as Wendy indicated, we talk about writing better contracts. How do we address that problem? And I've spent a lot of time looking at how, when you're drafting a contract, how that can affect parties after the contracts have been formed. So I've looked at how contracts may influence judges. So you may draft a contract to influence the judge or to influence the party as they may be situated after the contract has been formed to deter breach or things like that. But my thesis, the thesis of this article is that I believe that the principal agent problem as it exists post-formation, as well as problematic issues with the written contract such as consent, can be explained by the principal agent problem as it exists before the promises are made. So the literature about informational asymmetries so these exist, right? The informational asymmetries that may exist after the formation. Those exist. People have explained it, they've explained it well, right? And we talk about bounded rationality. And again, this explains people's behavior well. But why do they matter, right? Why do they matter in this context? And I believe they matter, or they're empowered, because of the principal agent problem as it exists pre-formation. So there's no need to sort of recap the principal agent problem or to talk about it again in the post-formation relationship. So I'm looking at it the pre-contract formation stage. So is one of the parties an economic agent of the other prior to the contract being drafted? And specifically with respect to preparing the contract. So one example you could think, the obvious one, is if you tell somebody, draft up the contract, right? Draft up the contract. You've empowered, you've delegated a task to somebody else. You've empowered them to do it, and they're doing it on your behalf. Now, obviously, we'll talk about the problems that sort of leads to down the road. But as far as the actual delegation of authority, that's an express delegation. Well, what about another situation? A lot of times there's not explicit agreement. One side may just propose a draft, and the other agrees either to work with it or just to sign it. And you're essentially ratifying, albeit not in a legal way unless you sign it, but you're ratifying if you accept the person's first draft, or you accept the fact that they did prepare it and you're willing to work with it, you've ratified the other side's preparation of it. Again, not necessarily in a legal sense, but you've certainly given them the authority in an economic sense to have prepared it on your behalf. And when the drafter presents this draft to you, they're essentially asking two questions. The first is whether or not the other party will agree to promissory terms and conditions that might, as they appear in the written contract, be different than those previously discussed or those that otherwise might govern their promissory transaction. Again, that's the first question. The second is, will the other party agree that the promissory terms and conditions will be as presented in the written contract as prepared by the drafting party? So with respect to a written contract, this second request must exist, or the written document would not exist. So choosing the execution of a written contract to be the method of contract formation and choosing a written contract to be evidence of the contract are additional, or at least different, features of the relationship. Again, the preparation of a written document correspondingly is a separate task. So if you're willing to make that jump with me, and assuming that the agency relationship exists, we may now explore why or how the principal-agent problem plays out in this context. So whether you can first look at whether or not economic value is created by the use of an agent, the contract preparer. So the agent's special characteristic, the expertise, the information, more time. So we could think about this in a lot of contexts where one side is always the contract preparer. It may make sense, right? The economies of scale, someone might be a repeat player. The information on what the contract needs, right? So that may make sense. There may be economic value to having one party always being the drafter, or even in a one-off context, be the contract preparer. The next factor, looking at the principal-agent problem, is whether or not the interests of the parties are different with respect to the task. So in this case, it's pretty obvious. When you're drafting the contract, that the interests of the parties may be diametrically opposed in some instances, right? The contract preparer realizes that this document is going to govern their rights and responsibilities post-formation, right? So they want more flexibility, they want less liability, and they want the opposite for the principal. And obviously the principal's interests are different, right? The exact opposite. The other thing that's, again, the principal-agent problem factor is whether or not the agent can take actions that further his interests at the expense of the principal's interests, right? So there are numerous examples of the contract preparer. We could talk about why standard form contracts look the way they are, wrap contracts, so whether or not they're lengthy, there's a lot of legalese, they're complex, the delivery process, unclear terms. So again, the agent can take actions to further their interests at the expense of the principal. And again, what you can also see is where the contract preparer can allow for opportunistic behavior after the contract has been formed, right? So you might draft the contract in a way so that the contract drafter can act in a desired way to shirk or to take private benefits or what have you after the contract has been formed. The other factor to look at is whether or not it's difficult or expensive to monitor or verify the behavior of the agent. And we might see this play out in different contexts. It doesn't always play out the same way, but it is a factor. So will the principal read the contract? Will they be able to detect opportunistic behavior with respect to the drafting of the contract? So consumer contracts. Do we believe that consumers are effective monitors of the drafting parties? And we might say no for a number of reasons, right? They don't read it. They don't understand it. They're boundedly rational. There's information asymmetries as to the terms of the contract. But this is just again, an agency problem. The principal, the consumer in this context, is unable to monitor, unable, you could argue, unwilling, to monitor what the principal, the drafting party, is doing. And even if the principal is able to detect what the agent did, so even if the consumer could figure out what's in the contract, the principal may be unable to tell what the agent should have done to serve the principal's interests. So again, even if you can read the contract, you may be unable to figure out how the contract should have been different. So again, if you're not a legal expert, how are you supposed to understand the meaning or the relevance, the importance of an arbitration clause? And again, the behavioral economics explanation for consumer behavior fits well here. Even if you can understand the terms, you may not understand the consequences of the term because of the optimism bias or things like that. So again, these factors, all these factors I've sort of run through, they play out on different contexts, and they play out differently depending on the different circumstances, and we feel differently about the contracts based on how those factors interplay. So the economic solution to this problem is to incur agency costs, right? So costs to prevent such behavior. So we might think of reading the contract or hiring an attorney. These are monitoring costs. These are costs incurred by the principal to monitor the actions of the agent. The agent's drafting. I'm not sure that I'm qualified, or I want to be able to detect their behavior. I'm going to hire an attorney to do so. You could also think of outside parties as agents. So even if they're not empowered by the non-drafter, if the government, there's government-imposed requirements. So if there's mandatory disclosure, so that's a monitoring cost. Or we look at judges; they look after the fact for improper opportunism before in the ex ante context, or unconscionability. So how does this play out with respect to contractual law reforms or contract law issues? So we talk about the trouble with consent in a number of contexts. So when contracts law scholars talk about the lack of meaningful consent to form contracts or similar issues, perhaps it's helpful to think about the economic conception of agency. Consumers, as principals, empowering drafters to prepare contracts are not, for a variety of reasons, in a position to monitor or respond to agents who act opportunistically when drafting. When we talk about new disclosure requirements like plain English, this can be seen as an externally imposed agency cost. Consumers cannot monitor absence the requirement for plain English, so let's help them monitor by reducing the ability of the agent to act opportunistically and draft poorly, or to draft at too high of a level, or to bury disclosures. Or maybe certain states require attorneys at closing for certain transactions. Again, maybe we require an outside monitor. When we talk about bulking up unconscionability or imposing a duty to draft responsibly, this can be seen as an agency cost, or an agency cost to monitor. Consumers may not be able to monitor, so judges or legislatures can step in to prevent agents' opportunistic behavior. Information asymmetries, that's just part of the monitoring problem. The fact that the drafting party may have more information than the principal, the consumer may not be able to, or if it's not provided in a fair form, we may need to help the principal monitor or to solve that information asymmetry by forcing more information. Bounded rationality, again, is part of the inability to respond. The whole idea of behavioral economics, the inability to respond rationally to contracts as presented. We don't believe that the consumer can respond rationally based on particular types of disclosure. And note that we're less concerned about these issues when we believe that the principal, the receiving party, is in a position to monitor. So when does this apply? So usually courts won't interfere when they believe, and Meredith Miller has done work on this, when courts believe that the other party's sophisticated. If you're sophisticated, you can protect yourself. Or if you have means, you can go hire an attorney. We are not going to step in and we're not going to stop opportunistic drafting, opportunistic behavior when you're in a position to protect yourself. So when you have an agent or expertise or means. So where does that leave us? I believe that the economic conception of the principal-agent problem provides one systematic model for the analysis of contractual law issues that arise from contract preparation. So you should examine in each instance the different prongs of the problem, including the differing interests of the parties, the agent's ability to act without oversight and control, and the principal's inability to detect or control the agent, including through the incursion of agency costs. So when the agent can prepare contracts in a problematic or troubling manner, one can now isolate the factors that comprise the principal-agent problem to determine the cause of the problem and to examine whether modifying one or more of them will fix the problem. So it helps explain systematic problems in particular areas. As Danny Hard indicates, the party that gets to dictate or impose terms during contract formation will usually get to keep and use those terms in the event of any subsequent contract dispute. Clearly, the party that has the ability to impose terms during contract formation is the party with the bargaining power to do so. From a societal perspective, then, I believe we need to be able to identify those issues where we do not trust the ability of the principal to counteract opportunistic behavior by the drafter. Unfortunately, most reforms seem to assume this ability away, or we only focus on the principal, or on the agent. We don't focus on the principal. So we don't address how other types of agency costs could be incurred to counteract such behavior. So in traditional models of agency behavior, principals can try to align the incentives of agents by offering benefits to the agent for proper performance, right? You might think of giving incentive equity to employees to induce them to perform better. I don't need to monitor that agent anymore because they're incentivized to do a better job because their interests are now aligned with mine. So how might that play out in the contract context? I'm still exploring that, but one sort of way to do that is it's kind of like a penalty default. If you want the benefit of a particular term, you might think about reversing the presumption of enforceability. You would tell the drafter, if you want the benefit of this part of a particular term, you might require repeat players that they would only get the benefit of that term if they can empirically demonstrate that the consumers understood the terms. So yes, you can get the benefit of the terms, but only when your interests are aligned with the principles that we're confident that they will understand it. So again, I'm still exploring other types of costs, such as bonding or otherwise, and I'm not sure how that would apply here. But I do believe, again, that the principal agent problem, as it exists in the contract pre-formation stage, provides us a useful way and a systematic way for examining a number of the contract law issues that arise all the time today. Thank you.
Okay, so all of our panelists kept strictly to their time, which leaves us almost 20 minutes for questions. Yes?
I have a question to Andrew. Thank you very much for very nice and very clear presentation. My question is, how to distinguish between ex tempore and ex post? Because my understanding is that in both cases, first party, which is court or dispute resolution court, they are coming in when a dispute arises after a dispute. So isn't it the same stage?
Yeah, so the first concession is, of course, I do think you could run it that way, and that's why the people who I was criticizing would not deny the existence of dispute boards. They would just say that they are ex post contracting. But I think there are useful and principled ways to draw a line. One is so ex tempore is going to be faster and different kinds of parties. But they could be radically faster or radically different kinds of parties in a way that you would never be comfortable calling adjudication or ex post contracting. So how fast? Well, the dispute boards can be on site that day and give you an answer that day, and they can give you an answer before you even knew you had a conflict because they spot the broken wall or they interview the employees and say, we're going to have a problem soon, let's clarify this term. So you could get pre-conflict or contemporaneous answers. And because for reasons I haven't explained to you, I believe that pricing terms in contracts that refer to price indices, like the S&P 500 or the LIBOR or the Platts, I think those things, strangely, for reasons that I can't get into, are they're agents of this kind. They're doing ex tempore contracting. They're picking your price for you on a daily basis. And if you were to buy that, read the next paper, if you were to buy that, then you're getting adjudication that is instantaneous, updated every day by people who don't know you and don't know you exist. That doesn't seem like the speed and the depersonalized character of it doesn't seem like ex post contracting in the traditional sense. And again, the trade association ISDA that I put up there, they do this kind of thing, but they do it for a large group of contractors, many of whom they don't know. So I think there are a lot of things, and these things, in this case, are not enforceable judgments. They're recommendations or evidence. I think these are ways that we can begin to at least create a principled way to identify this space. And then the question is going to be, is there a payoff to doing that? And I think there is a payoff to cordoning it off.
Okay.
I love the panel. I have questions for all of you, but I'm just going to ask Wendy. This was because I used to do government contracts, and so we don't have enough. We don't have enough of us focusing on what is a huge part of the range. But in contracting to run a prison, there are various forms of contracting that you could use. You could use a time and materials contract, so much per head per day. But that doesn't work in areas like prisons because you don't have competitors. It's real well for garbage services and laundry services. You can make it cost plus. We all know the problem with that. You're encouraged to spend more money. You can make it cost plus fixed fee, which is popular. You get the same amount no matter what your costs are, the same amount of profit. Or you can make it cost plus incentive fee. And cost plus incentive fee, of course, is much more popular today. You get more money if your costs go down. But one of the problems that I don't know if you've run across yet is that contracting officers in the real world have an outside audience. The outside audience is the head of the agency or the congressman who says, well, those people made 27% on the contract this year. How did that happen? And you say, well, they did a really good job. You say, well, no, you did a really good job letting the bid out because somehow or other you left money on the table. And so there's that monitoring function in there that I think impedes the reciprocity norm in that situation. Ideally, you'd want the contractor to make as much money as humanly possible as long as the total cost of the government was down and the services were fine. So I think it's a little more, I think you have to take that into account in your reciprocity account. Because in the good old days, when I was doing missile contracts, there was perfect reciprocity. I mean, everybody was part of the same team and everybody loved each other until Congress started doing hearings, at which point it got very confrontational. So I really like what you're doing and I hope you get into it more. But that's just a thought.
So Wendy, for the purposes of YouTube, we're supposed to summarize the questions.
Ooh, that's very loud. Okay, so for purposes of the YouTube audience, I'm not even going to try to summarize the question, but I will. But I will say this. So the question goes to how does the cost play into the parties' incentives during the contract, and I agree that there are so many different ways that you can structure contracts. I am sort of focusing on this cost plus incentive contract that you have flagged because I do think that that is really the trend here, the way that at least the scholars are suggesting that governments go, and I think that that is the way that governments are going in these contracts, although we could use a study on that. But I think what you've pointed out is a good, actually it sort of helps my paper because there's this push on the cost side. So a contract is viewed as successful if it reduces cost at the end of the day. I mean, that's how the contracting agents are viewing it when you talk about the supervisor for the contracting agent. I mean, at the end of the day, it's really the cost that they're focusing on. It's not necessarily the service. So when you reference monitoring, you're talking about monitoring for cost purposes, though, not monitoring for purposes of service quality. So not are prisoners getting good health care, or are people that are signing up for welfare benefits actually getting them when they deserve to get them based on the statute, that sort of thing. And so that's really more where my focus is. How do we incentivize the parties while they're in this relationship, or how do we incentivize the private actor to do better work when we can't do it by monitoring, because we're not discovering through monitoring that these problems with poor service are occurring. So I want to frame the contract in such a way that the parties are going to act collaboratively, and so that the contracting agent is going to want to provide better service and be incentivized to provide better service. And so that's really been my focus. Thanks for the question.
Yeah, thank you very much. I enjoyed all the papers, and I've got two questions, if I may. The first one, maybe a slightly more mundane point for Kenneth and Andrew. I think you both pick up on a similar topic in that you talk about cases which have been decided in spite of the facts in a way. Because we talked about Hadley and Baxendale, and if you read the case report very carefully, it says somewhere that the miller actually said, this is my only crankshaft, I haven't got a spare one. And then later in the judgment they go on to say, well, they had to assume that there was a spare one, so which is, unfortunately, I think we can't do quite the same research that you have done in the other contract to find out what have they actually, there was no written contract, I think, at the time, but that was just an observation which crossed my mind. The second point, I think, maybe more concerning this conference as a whole, we seem to have a friction here between the perfect contracting people who want to write down contracts with 1 million clauses foreseeing all the possibilities, and then we have the more realists who say, look, you can't agree on everything, and that it might be too expensive, it might be impossible. And so the question is then maybe, what is a better contract? Is a better contract the most detailed contract, or is a better contract one that strikes a balance between cost and expectations, or what can you possibly agree ex ante and what you have to leave for ex post settlement? And that also goes back to what we heard yesterday.
Anybody want to
I mean, I can be very brief on that because you know what my answer is, which is that the better contract is not the most detailed possible contract that you can write. But not only for reasons of cost, but also because it doesn't create an environment where the parties are going to want to maximize the joint benefit in the way that the traditional law and economics conception is of these sorts of things. So let me defer to others.
I haven't thought a lot about how detailed contracts should be, but let me give kind of an off-the-cuff thought from this Thomist perspective. I think that the answer might depend on the intent of the parties, and that there may be some situations if the parties want to be extremely specific about what they want to get out of a contract, then that's good for them. This Thomist perspective focuses on this relationship of commutative justice, an equal exchange in which both parties exchange something of basically equal value, which sort of comes from Aristotle, and I think that might help at least bolster an argument for less detailed contracts, because the Thomist perspective is not as concerned about exactly what terms did you agree to. They're concerned about the type of relationship you've entered into, and so that's how I think I might go about answering that question. But it might depend on what parties need given their particulars in any transaction.
The best statue might be the David, but it doesn't mean that we want to encourage people all to make the David when they sit down to do some art projects. You know, I mean, there's a sense in which the best contract might be a very detailed one or a relationship-specific one, or but what we want our courts to encourage and what we want to tell our clients and what we want our scholarship to identify, you know, a lot of people aren't going to be served by the best contract. The best contract for them might not be the best contract, and just keeping that in mind, however you want to use the word best is fine.
I guess I would just add, for my part, obviously my focus on is less on what contracts can get right, and then less that, or more what can they be doing wrong, right? So I'm focused more on the front end. When might we be concerned about why the contract's problematic versus when is it working well?
Yes. So I want to ask all of you, or think aloud, that there is a theme that is running across those presentations that has to do with the old but not totally understood idea of good faith. And I think that good faith can really explain a lot of what you were talking about. And, you know, Kenneth, for you, I'll just back up a little. Good faith, assuming that good faith can add duties and good faith can restrain discretion. So I think that you can hear Cardozo is talking about good faith. It's not okay in terms of good faith to really insist on a pie that there is no distinction between the two kinds of pies, and no one argued that. And so you can kind of think about it as a way that Posner actually writes about as well, and no one will say that Cardozo and Posner kind of were thinking about it similarly. But even when General Motors was trying to argue that the finish of a building at a certain time of the day in a certain angle does not really fit, and therefore they can refrain from paying, even Posner said, hello, there is a limit. And I think the limit is, and he didn't say that, but the limit should be good faith. And I think moving to Wendy, that's, I think, one prescription to writing a better contract is to minimize those details, but you mentioned standards, and I think it's one standard that is perfectly useful here is the idea of good faith, because it emphasizes this collaboration aspect, and there is a reading of good faith of fulfilling the spirit of the agreement, and I think that will fit or can fit really nicely with prisons and education, because while you cannot specify, there is a spirit that is going on, and I think good faith can really work out. And Eric, I think that in drafting in this relationship of agency, we call it in the context of agency fiduciary duty, but it actually is similar to the idea of good faith, and you can think about this kind of good faith duty that the agent has towards the principal, and that can be a fiction. Now, the problem in the American context is that good faith is so much weaker than in other countries, right? So, for example, to apply to Eric, while it's very, very helpful, the whole notion of pre-contractual good faith is really an obstacle. But in Europe, for example, good faith applies to the pre-contractual phase, and in some decisions when the good faith here is strong enough to really do the work, in other decisions it's not working that well. For example, at will employment, where there is no good faith. But but again, assuming some strength of the idea, or better, more strength of the idea of good faith, I think it's kind of a theme, but I don't see how it applies to you.
Can I just add a 2-second gloss?
Which is nothing more than to say that Judge Posner's gloss on good faith is that good faith is there to prevent opportunistic behavior, in post-contractual relationships. And so it really does fit in very nicely with Eric's theme, I think. So.
It's funny you mentioned that, because this actually leads into what my next project is going to be, which I hope is going to be an empirical study on good faith and fair dealing, because I'm curious if what Posner posits as the economic rationale, which is that it does deter opportunistic behavior during the course of the contract, is true or not. But my problem with good faith and fair dealing, from my perspective, is that we're really talking about it in a litigation context now. So, what will a court impute is the meaning of this contract, and what were the duties of the parties under this contract. And so I really want to focus on, because these don't necessarily result in litigation, what the impact is on the parties while they're actually in the contract. So that's why I want to test good faith in that way. If you tell parties you're bound by the duty of good faith and fair dealing, you're bound to act collaboratively, will that actually change their behavior or not? And I hope it does, but I want to test that.
To me, what was fascinating about both Wendy and Andrew's papers was this aspect, this kind of, I don't know if it's psychological or timing or some issue of fairness, but if you get the parties at the right time in the process of the contract, they'll act really differently. In the Jacob and Young's case, a lot of people think, and I don't disagree, that by the time Kent decides to withhold payment, there's been a lot of friction between the parties. They're sort of at that dispute point, and if you've litigated, you know that there's a point where you're working with your parties, and it's as much for them about winning as it is about a particular result that they need. But if you catch them early, they will sort of engage in reciprocity. They will abide by good faith. I think, for me, again, this, when I think about this from this Thomist perspective, the Thomist has this sense that people do enter into these relationships without explicitly saying it, but knowing that they mean to enter into a fundamentally just relationship. And so I agree with your statement. I really like Cardozo's opinion if it were written for some other case. The problem is that there's so much distance between what Cardozo wrote and the actual facts. I always have a little bit of a difficulty when somebody feels like they can't tell me what really happened, but take their word for, how I should interpret it. But I totally agree with your points.
My comment is that if you did impose a similar requirement, so for pre-contractual obligations, that would be in a externally imposed monitoring cost, right? So the legislature would impose it, or maybe we could develop it judicially, and then it would be another monitoring cost. So again, I think it does go to the principal agent problem, and how do we address opportunistic behavior? Well, maybe we have an outside party monitor to decide whether or not they were acting opportunistically pre-formation. So thanks for that. That's helpful.
We have time for one more question.
So my question is for Kenneth, and I'm very sympathetic with the project. I'm wondering if you can say a bit more. So I have two specific questions and then general questions. Would a Thomist care why Kent wanted a reading pipe installed? Put that a little more generally. Would the Thomist care whether the condition precedent was a reasonable one? I'm worried of the facts where it's clear it was a condition precedent. And then more generally, are there within Thomism those who are relatively paternalistic or relatively individualistic with respect to some of these issues? And then the most general way to put the question, if you prefer it, what does the identification of the common good as the point of contracting or human reason as the way to get to the common good? What do those add to the paternalism, individualism debate that you identify between Cardozo and the lower court judgment of the term, or more generally between paternalism and individualism and contract theory? And so the thought that occurred to me was it might provide a somewhat more concrete way to determine the reasonableness of conditions precedent. And so I'm wondering if that's what you're getting at.
That's exactly right, your last point. Those are all great questions. I might not be able to answer them all without exhausting all of our time. Why does the Thomist care why Kent wanted the reading pipe? The answer is yes. Because of the common good, we think that you should only enforce promises that are directed toward the common good. This is why it matters, however, that there's no allegation of unconscionability. the Thomist says, you can basically enter into a contract for reading pipe if you want reading pipe. The way we're going to figure out if it was directed not toward the common good is if you didn't get a reasonable price for that term. To get to your question about are there a variety of approaches in terms of paternalism and individualism in, I suppose, a Thomist framework, I think the answer is yes. I sent this to James Gordley, whose work I use a lot, and he thought, no, this contract's unconscionable. And we shouldn't enforce it because it's not directed toward the common good. I said, well, we don't have evidence. We need evidence of market price to determine whether it's unconscionable. And I think he accepted that point. But anyway, point being is James Gordley thought, yeah, you should invalidate this contract. It is unconscionable using a Thomist framework. And so I think you're exactly right. What the common good adds to this theoretical conversation is it gives us a reason for thinking that promises create moral obligations that isn't rooted in just individuals or just society, both of which unmoor that moral obligation in a way that I think is theoretically problematic. I'm going to stop there. Thank you.
Thank you to the panelists.